mulheres que são como o vento das monções. Movem navios, levam e trazem novidades, desconhecem fronteiras que as aprisionam. Rebelam-se, portanto, contra as amarras que insistem em querer cortá-las. Deixe-se entregar aos ventos e embarque nessa viagem com a gente. Será um prazer tê-los e tê-las a bordo.
Boa tarde a todos e bem-vindos a mais um episódio da primeira temporada do Monções Modernas, uma live do Modernitas. Meu nome é Marcela, eu sou doutoranda em História Moderna escocesa e hoje nós temos o prazer de conhecer e conversar com a minha colega Rebecca Mason, doutora em História Escocesa pela Universidade de Glasgow. Nossa live, por razões óbvias, vai ser em inglês e ela será dividida em 3 sessões. Primeiro, nós teremos uma entrevista para entender melhor a trajetória da nossa convidada e os desafios que ela enfrentou até chegar nesse momento em que ela está hoje. Depois, vamos ouvir uma apresentação que ela preparou para nós, que irá tratar da relação entre mulheres, patriarcado e a lei na Europa moderna, com seus devidos paralelos com o contexto escocês. Ao final, abriremos a oportunidade para que vocês façam perguntas. Fiquem à vontade para fazerem perguntas em português, caso queiram, que eu me encarregarei de traduzir. Além disso, gostaria de pedir, por favor, que a gente mantenha o chat só para perguntas e assuntos importantes, e qualquer mensagem indesejada será apagada. Antes de eu passar para a introdução em inglês, eu vou fazer minha autodescrição. Eu sou uma mulher branca, de olhos e cabelos castanhos. Cabelos são lisos e longos, mas hoje estão presos em um coque em cima da minha cabeça por conta do calor absurdo que está fazendo em São Paulo. Eu estou vestindo uma blusa cinza e uso óculos de armação dourada. Com isso dito, eu vou passar para as apresentações e introdução da nossa convidada, agora em inglês. So welcome back everyone to the 4th episode in the first season of Monções Modernas, a YouTube Lives project organized by Modernitas, the nucleus of early modern history at the State University of Campinas in Brazil. My name is Marcela, and I am a PhD student looking at the relationships between language, politics, and the law in early modern Scottish witchcraft trials. Today, the winds took us further north in the Atlantic, a place that personally ended up being more than my own. In our first English episode, we will discuss how women, patriarchy, and law related to each other in the dynamics of early modern Europe in comparison to Scotland, the main focus of study of our lovely guest, Dr. Rebecca Mason. Dr. Mason is originally from Belfast in Northern Ireland, but crossed the Irish Sea to develop a PhD at the University of Glasgow in Scotland. Her research, funded by the Arts and Humanities Research Council, was part of the project Women Negotiating the Boundaries of Justice, Britain and Ireland between the 12th and 18th centuries, in which she looked at the way Scottish women and wives in Glasgow thought about, developed arguments, and actively protected their properties and possessions throughout the 17th century. In 2019, Rebecca started a postdoctoral project at the Institute of Historical Research in London, where she broadened her source base to include the experiences of women negotiating the law in Inverness and St Andrews, therefore adding a Highland and East Coast dimension to her PhD study of Glaswegian women. Therefore, after concluding her postdoctoral research in London, Dr. Mason returned to Glasgow to start a new postdoctorate project in the School of Law. Her work is entitled Women, Marriage and Law in Scotland, Historical and Legal Perspectives, and it's funded by the Economic and Social Research Council. In this most recent research, Dr. Mason is looking at how female property rights could have been impacted by local traditions, cultural identities, confessional dynamics, and changes in the political demography previous to the passing of the Act of Union in 1707. Welcome, Rebecca, and thank you so much for being here today. Could you tell us a little bit about you, yourself, and also do your self-description, please?
Yes, of course. Thank you for having me here today, Marcela. So my name's Rebecca. I am a woman in my late 20s. I have curly blonde hair. I'm currently wearing glasses and a purple dress, just for anyone who's visually impaired. So yes, I am currently in lovely rainy Glasgow at the moment. I moved here around 6 years ago from Belfast, and I actually studied for my undergraduate in history and English literature in Queen's University Belfast, and then I continued my research and I studied for a master's in medieval and early modern history at Queen's University Belfast, and that's when I became interested in women and law during the medieval and early modern period. So I actually looked at Irish women and property law for my master's dissertation, and I looked at women and warfare through the lens of the law, and I was interested in how women negotiated their legal status in various ways, such as when they were married, when they were single, or when they were widowed. And this kind of led to my interest in looking at Scotland. And I actually moved to Scotland quite organically. I seen an advertisement for a PhD in the University of Glasgow underneath the supervision of Professor Alexander Shepherd. And the project was just simply to look at women and the law in Scotland. And I actually didn't really know much about Scottish history when I started out. So I kind of came very new to the field. But yes, I moved here 6 years ago, and for the past 6 years, I have been very much immersed in the records of women and the law in the Scottish, in the early modern Scotland, and I'm happy to chat more about this later on in the presentation.
Perfect. Thank you so much, Rebecca. I'm just going to go through a couple of housekeeping, and then we can start our interview, if that's okay. So before we begin, just a couple of housekeeping instructions. This episode will be divided into 3 parts: an interview, a paper, and some questions at the end. In the first part of the interview, we will discuss with Rebecca her academic journey and challenges in an informal and relaxed conversation. For the second part, Rebecca will present a 20 to 25-minute paper on women, patriarchy, and law in the early modern Europe, which she kindly organized in order to trace differences and similarities between Scotland and the continent. Lastly, we will have our Q&A session in which you can ask Rebecca questions using the YouTube chat. Let's keep the chat messages to a minimum and really only use it to address our speaker of interesting and engaging inquiries. And with that said, we might start our interview. So Rebecca, you already mentioned this a little bit, but here in Brazil, we sometimes face the confusion of how Brazilian scholars end up studying non-expected corners of Europe and not the history of our own country or nations associated with it. How did an Irish woman ended up studying the history of Scottish women specifically, and why law as well? So tell us a little bit about how was that for you?
Yeah, apologies. I kind of went over that quite quickly at the start there. Yeah, it kind of just, it was just an interest that kind of developed throughout my undergraduate. When I was studying at Queen's Belfast, there was actually very little modules or courses that looked at gender history in particular. And that's kind of where my actual main interest stemmed from. I was interested in gender history, and I was looking at things like women in 6th century Byzantium and other kind of topics around that. And that's when I kind of became interested in Irish women and the law in the medieval period in Ireland. And this is kind of how I kind of branched into the Scottish perspective. I was interested in Gaelic law in particular. And there was some sort of, there was sometimes contrast between what was happening in Gaelic parts of Ireland with Gaelic parts of Scotland, of course. So that's kind of where the interest lay in the early stages. And when the PhD studentship came up, I realized that actually this is something that I could really further develop into the early modern period. And luckily, the early modern period in Scotland, you know, the records are written in Scots, so I could easily kind of understand what's going on. But I suppose what kind of shocked me when I started in 2015 was that women in early modern Scotland is actually quite an under-researched topic. So if you look to contrast to what is going on in England, you know, in the 1990s, there was quite a lot of books written about women in early modern England. And for me, it seems that the Scottish history context is kind of catching up with that now. And we've got fantastic scholars like Elizabeth Ewan, Catherine Spence, Katie Barkley, who've been working over the past few years to actually push the history of women in Scotland to the forefront, but I think it's kind of an ongoing process. And that's why for the past 6 years, I've been very much focused on the history of Scottish women. And I'm yet to kind of move my focus from that at the moment.
So speaking a little bit about this transition between medieval history and early modern history, and also between Ireland and Scotland, did you find any trouble in terms of the Gaelic language? How was that for you? Was it challenging? How did you deal with it?
Well, luckily enough, I mainly deal with translations. Unfortunately, having been educated in Ireland, we're not really multilingual people, and but I kind of rely a lot on legal handbooks and writings around the time. And unfortunately, I haven't really found many examples of Gaelic writings, and even Inverness. So I've been looking at Inverness over the past year, and everything is still written in Scots, apart from people's names. So people they will have Gaelic names in the court record. However, the court record's translated in Scots. So it's hard to access that, the kind of Gaelic identity at the moment. However, it's something I'm hoping to push forward. Unfortunately, the archives have been closed for the past year because of the pandemic. So I've kind of been relying a lot on digitized records online, on scotlandspeople.gov, and also other kinds of, like the Star Society online, which has a lot of legal writings. But hopefully once the archives reopen, I'll be able to kind of delve into that issue a bit more.
And how was the transition between studying literature in your undergrad, right? And then moving to the topic of law in history?
Yeah, I suppose I did English literature and history because I suppose when you look at the medieval period, much of the kind of surviving sources are usually like chronicles and literary text. So I actually think the two disciplines work quite well together. Now I'm moving to law, so I'm currently based in the School of Law. I'm not a legal expert in any sense, and I think I rely a lot on much of the groundwork that's been done by legal experts over the past 50 years in Scotland. However, I do think that the two disciplines can work really well together. So as historians, we're sometimes looking for different things in the records. So I'm interested more in how women described their property, how they described their situations. However, legal experts might be more interested in the intricacies of the law. And so I think as two disciplines, we actually work quite well together, despite the fact we have very different skill sets.
Yeah, perfect. Now, I would like to shift the focus a little bit and look at the consequences of our work in the present moment. Sometimes the general public and even some academic colleagues find themselves a little bit confused about why we study a particular subject and what's the relationship between this subject and modern history. At the same time, we know that not necessarily historiographical study has to have a direct relationship with the present. Where do you think your research fits in regards to this debate, and how could it contribute to shed light in our modern society?
That's a really interesting question. Well, I suppose, as a woman, I have always been interested in the history of women in general. When I was applying for the PhD, I kind of, living in Northern Ireland at that time, back in 2014, women didn't have the same healthcare rights as men. Women were politically disenfranchised in many ways. So I've always kind of been interested in how women in the past were able to negotiate, patriarchy, which was a much more pervasive system than it is perhaps today. But I think in my current project in the School of Law, I'm trying to basically link what was happening in the past in order to understand more about women's position in society today. So, for example, most kind of legal experts will look at at periods of history when there was kind of a massive seismic change, such as the Married Women's Property Act in the 19th century. And what I'm trying to say in my current project is actually looking further back and looking at what women were doing before the courts. We can perhaps see some interesting examples of how women were able to overcome the problems that they faced in society. One of the interesting things that's happening today in Scotland is they're currently reforming cohabitation law. So cohabitation is when a couple live together whilst unmarried. And legal commentators kind of comment that this is a very modern relationship. But of course, in Scotland, cohabitation was seen as a form of marriage in the 16th and 17th century. So women could be married by habit and repute. So this was basically, they didn't have a formal marriage, but they were still seen as married. And women in the past were entitled to certain kinds of property if that relationship was to end following the death of their partner. So I think what I'm trying to do in my current project is to kind of show this really rich history to current legal reformers and government officials, to say that actually looking at women 400 years ago is just as important to understand women's situation today in Scotland and of course across the world.
No, perfect. That makes total sense. And Rebecca, why study Scotland and why is this important today?
Well, I think given over what's happened over the past decade, it kind of brings to fore the importance of studying Scottish history in its own right. I think Scottish historians, we sometimes struggle with our identity within the field. You know, sometimes Scottish history is kind of amalgamated underneath British history, and I'm sure you've read many books that are on early modern Britain, and they might only have a paragraph on Scotland. This happens a lot. But you know, in 2014 we had the Scottish independence referendum. We've recently had Brexit, and I think we're really seeing the importance of looking at Scotland in the past and understanding how Scottish people kind of navigated this complex world when, after the 1707 Act of Union, there was, you know, massive changes across the British Isles entirely. But also, I think for me, the importance of it is looking at Scotland in its own right shows the differences between the two countries. And I'll talk a bit about this in a moment, where, you know, Scotland is just as important to study in its own right as England. And I think sometimes we struggle with convincing people of that, right? But I'll get into that a bit more. But I hope, yeah, it's complex.
And how do you see yourself in terms of all the political debate that there is in Northern Ireland as well at the moment? What place do you see yourself being Northern Irish and studying Scottish history?
Well, that's a difficult question. Of course, Northern Ireland's a very fraught place historically and currently. So this year we've got the centenary of Northern Ireland as a state. I was brought up Irish. My background, I would say that I'm Irish, so I have certain feelings about that. But I think just what's happening in Northern Ireland this year with the centenary just reiterates that we need to understand the history of where we either come from or where we live. So whilst I'm an Irish woman, I kind of see myself now as a mixture of Irish and Scottish. And mainly that's because of my research interest, but also because I feel like I am a Scottish citizen just as much as I am an Irish citizen. And I think that's the most wonderful thing about Scotland, is it's such an open country and it's welcome for everyone. And I think Scotland is very much a European nation rather than a British nation. And I think we'll see this kind of being played out over the next few years.
Yeah, hopefully. So Rebecca, I'm gonna pass that to you now for you to present your paper to us. I will disappear for now, but I will be here if you need anything. And yeah, so you have like between 20 to 25 minutes, if that's okay, but no pressure if you want to speak a little bit longer as well. We will be very happy to hear you anyways.
Thank you.
All right. No.
Okay, so my presentation today is called Women, Patriarchy and the Law in Early Modern Europe, Perspectives on Scotland. So my research reconstructs the property rights of early modern Scottish women by comparing the laws governing legal status and property transmission with women's everyday experience of inheritance, marriage and widowhood in Scottish towns. So as we will hear today, women had access to a wide range of Scottish law courts to preserve their property rights, and local systems of justice oversaw the administration of laws regarding women, their children and their property. So drawing upon the richly detailed records of borough and commissary courts in 3 Scottish towns, this includes urban Glasgow, Highland Inverness and scholarly St Andrews, My research traces women's property rights and concerns from youth to old age. Now, before turning to my own research, however, it's important to briefly explain women's experience of law elsewhere in Britain and Europe. In general terms, to contextualise women's experience of law in Scotland. So legal codes across early modern Europe limited women's capacity to access law or own property based on their marital status and their position within the family. For many historians, especially those of early modern England, the two key offenders were the custom of primogeniture, and this basically directed landed property to the eldest son, and the rules of coverture in marriage, which subjugated wives to their husbands. Patriarchal property relations sought to regulate women's capacity to own land or goods without male assistance or intervention. So a definition of coverture was provided by William Blackstone in his 1765 publication, Commentaries on the Law of England. So Blackstone wrote, "By marriage, the husband and wife are one person in law. That is, the very being or legal existence of the woman is suspended during the marriage, or at least is incorporated into that of her husband, under whose wing, protection, and cover she performs everything, and is therefore called in our law French, femme couvert, is said to be covert baron, or under the protection and influence of her husband, her baron or lord, and her condition during her marriage is called her coverture." So coverture gave the husband near absolute control over his wife's property, as well as her person. Married women were described in legal handbooks as perpetual legal minors, divested of the possibility of economic independence. The extinction of a wife's legal identity is what lawyers commonly refer to as civil death, the logical conclusion of the unity of persons. The historian Sarah Butler has argued that in essence, a wife becomes Mrs. Him. Their legal personalities are so firmly merged, she cannot have a separate existence. So much so that when a woman acts in her own right at law, she is construed as acting on the behalf of her husband, such as his attorney or under his influence. The historians Tim Stretton and Christa Kesselring have also argued that a typical wife in New England in 1750 had much in common with a typical wife in England in 1250. Subordinated to their husbands in most matters relating to law and property, both had scant protections should their husbands turn against them. The repeated usage of the terms baron and femme in English law also constructed a pervasive impression of marriage as a feudal hierarchy. So women are often defined as either married or unmarried in legal handbooks. Their immediate marital status influenced their ability to approach the law as independent agents. So unmarried women, such as single women of age and widows, were entitled to enter into economic contracts or initiate litigation without receiving male consent. Married women, however, were forbidden from accessing the law without receiving the consent of their husbands. A married woman could technically not own property, sign legal documents or enter into a contract, obtain an education against her husband's wishes, or keep a salary for herself. The English common law doctrine of coverture did not affect all married women in England, or indeed those living under British rule elsewhere. So, for example, certain types of courts in England did follow civil legal procedures, which entitled married women to appear before the courts as independent persons. So in England, the courts of chancery and requests granted married women with the ability to exert considerable legal autonomy. Tim Stratton has argued that these courts even allowed wives to sue their husbands, a clear recognition that wives were, in fact, legal persons. It's clear that despite the limits of coverture, married women were active litigants in early modern England. So turning to Scotland, we see a similar yet slightly different system that regulated women's legal status and access to property. So Scotland had in the past, and still does to this very day, a separate legal system from that of England. So coverture was an English common law doctrine and did not necessarily apply in Scotland. During the 16th century, Scottish lawyers increasingly trained on the continent, and as a result, Scottish legal principles were heavily influenced by civil law. So Scottish women could approach a wide range of courts when asserting their property rights. And unlike English women, they did not have to approach certain jurisdictions in order to circumvent the doctrine of coverture. So rather than living under coverture, the Scottish wife was subject to a doctrine called jus mariti, and this asserted the husband's control over the marital estate, while recognising that she held distinctive rights to certain kinds of property, such as inheritance. Different from England as well was that a Scottish wife retained full ownership of her paraphernalia, and these included personal items of worth, such as clothing and jewellery, so basically property that was gendered female. In Scotland as well, widows inherited certain kinds of property following the death of their husbands. Widows, they gained ownership of a customary share of 1/3 of their late husband's goods, which increased to 1/2 if they had no children. Widows were also entitled to claim the custom of terce, and this was basically lifelong rights to 1/3 of the husband's landed estate, or the lifelong use of their jointly owned land, and this was land held in conjunct fee. So my research explores the property rights of women from 3 urban towns in Scotland: Glasgow, Inverness, and St Andrews. Now, these 3 towns were all quite different in economic function, size, and prosperity, so they provide a range of context for studying women's property and choice of legal avenues. So Glasgow was an increasingly important commercial centre throughout the 17th century, with the River Clyde providing the passageway for ships from all over the world. The town's population grew drastically too, from 6,000 inhabitants in 1600 to 15,000 inhabitants by 1700. Now, St Andrews was a much smaller settlement on the east coast, with less than 4,000 people at the end of the 17th century living there. Yet, like Glasgow, it also had an established university and a seaport. Inverness was considered the gateway to the Scottish Highlands and was frequented by men and women living on the cusp of the Gaelic hinterland. Similar to St Andrews, Inverness boasted a modest population of about 3,000 inhabitants, most of whom were Gaelic speakers by the late 17th century. I primarily focus on urban women who came from the families of craftsmen, merchants, and urban professionals. So the women at the heart of my research range from the daughters of labourers, craftsmen, and merchants to the widows of clergymen, lawyers, and some university men. Now, some of these women only possessed minimal rights to clothing or small amounts of money, whilst others were invested with substantial rights in buildings and plots of land. There's surprisingly very little research into the popular uses of the civil legal system in Scotland, especially in relation to women. So due to the quality of the material, gender historians have tended to focus on women either in relation to the operation of Calvinist church discipline in the Kirk sessions, and this is examples of women committing acts of sexual transgression or scolding, or the administration of justice in Scottish criminal courts, such as women's involvement in witchcraft and infanticide. Now, in recent years, Scottish gender historians such as Elizabeth Owen, Catherine Spence, and Katie Barclay have dispelled the myth that women were legally and economically incapacitated within marriage. So Catherine Spence, for example, has discovered that married women formed the largest proportion of female litigants in the debt records of the borough courts of Edinburgh, Haddington, and Linlithgow between 1560 and 1640. Locating wives as producers and consumers of a wide range of goods and foodstuffs. Yet, while it is now accepted that married women were highly active in credit networks in Scottish towns, there's still a limited understanding of how women negotiated the laws of inheritance, marriage, and widowhood. Family law was one of the main controllers of the redistribution of wealth in Scottish society. Inheritance law directed the flow of resources between generations and within families, just as marital property law directed the flow of resources between husbands and wives. the direction and transmission of women's property through these avenues, and the extent to which these rights were protected before the courts was decisive for individual women's lives. So I specifically look at women's engagement with two separate law courts in Scotland, and this is the Borough Court and the Commissary Court. Now, the administration of law in early modern Scotland was complex, decentralised, and largely private. The Borough and Commissary Courts exercised civil jurisdiction over different but at times overlapping matters that concerned women's access to property. The Borough Court, headed by town bailies, dealt with the registration of contracts and disputes related to land, goods and cash. The Commissary Court, headed by a commissary judge and his deputy, followed a mixture of canon and civil law after the Scottish Reformation of 1560, and exercised jurisdiction over the proving of wills and testaments, matters relating to a deceased person's estate, and actions for care provision. So just on the screen, I've got an example of where these courts would have been situated in Glasgow. So the Borough Court was at the toll booth in the centre of the town with the blue arrow. The Commissary Court in the red arrow was situated in the southwest tower of Glasgow Cathedral, which was unfortunately demolished, I think, in the Victorian period. So today I'm just kind of going to focus on the Commissary Court, as this particular court dealt with issues relating to inheritance, marriage and widowhood. Now, the women who presented themselves before the Commissary Court were not particularly exceptional individuals, and much of their behaviour conforms to existing evidence of women's conduct. This allows us to pursue what the feminist historian Joan Scott has defined as the purpose of gender history, and I quote, "Not the recounting of great deeds performed by women, but the exposure of the often silent and hidden operations of gender that are nonetheless present and defining forces in the organisation of most societies." So as I've already mentioned, unlike English women, Scottish women kept their own surname upon marriage. Now, this practice actually stemmed from other civil legal traditions, with the historian Julie Hardwick finding that married women in early modern France similarly retained their family surnames upon marriage. Now, Scottish women kept their family surname as the marriage was intended to create an alliance between the kin group and the husband's kin group. It also reflected how the wife's kin group retained a vested interest in the property that she brought with her to her marriage, as the kin group were entitled to retrieve this if she died without having any children. More importantly, the practice of Scottish women retaining their own surnames also makes it possible to trace their marital careers within the legal record, with Scottish sources providing information that's often hidden in other polities. So the legal process of placing a wife's name before her husband's name in the court record makes it possible also to identify when the context of the contract or a legal suit concerned her alone and the husband was simply named for his interest. And here's an example on the screen of this being played out in the Commissary Court. So here we have a remarried widow taking her children's legal guardians to court, and they're basically arguing over care provision. But looking closely at the record, it says Jean Findlay, relict, which meant widow, of the deceased John Ritchie, merchant in Glasgow, and Mr. James Reid, now her husband, for his interest. So, you know, this is three different people with three different surnames, but she is being described in relation to her deceased husband as well as her current husband. And the phrase "for his interest" basically denoted that the husband was being named for his interest in the case, but actually the context of the dispute concerned Jean as the widow and the mother of the children. So just very briefly, here is a breakdown of the kind of court records that were heard before the Commissary Court in Glasgow. We see nearly 30% of the disputes across this period were involved testamentary disputes or executory disputes, and this is basically when someone died and there was debts related to the estate, and it was usually women involved in this because they were recovering for a variety of property, perhaps owed to their husbands or other family members, and that women would act as executrixes or executors on quite a frequent basis. So on the next slide here, we see I've given a breakdown of the sex of litigants in Glasgow's Commissary Court. So as we can see, women were highly active as litigants in Glasgow's Commissary Court across the 17th century. So women appeared as nearly 20% of plaintiffs in this court, and a plaintiff was often called a pursuer or a complainer in Scots law. It was just simply a person who brought forth a case. And women appeared as nearly 30% of defendants across the period, and a defendant, often recorded as a defender in Scots law, was also a person who was called to answer a case. Now, these figures are noteworthy as the Commissary Court primarily dealt with issues relating to property. Inferior church courts in Scotland, such as the Kirk Sessions and the Presbyteries, heard cases relating to defamation, sexual misconduct, and household violence. So the legal actions of women in the Commissary Court actually largely mirror the activities of men. A detailed breakdown of women's varied involvement in litigation also reveals that they could be unwilling defendants as well as active plaintiffs, and could manipulate the law as well as fall victim to it. So just further breaking down statistics in the previous slide, I have shown here the marital status of the litigants in Glasgow's Commissary Court. So what is interesting about the Scottish context is we can break down married women's litigation into three separate categories, and this is mainly because of the name and practice of retaining the natal surname. So wives can be found as sole plaintiffs or sole defendants. They can be found as co-parties with their husbands, or they appear as remarried widows. So when a wife appeared as a sole plaintiff or a defendant, their husband was simply named for their interest, for his interest in the suit. So for instance, when Janet Wood, the wife of Alexander Main, a writer, appeared as a plaintiff before the Commissary Court in 1625, this concerned unpaid rent on a brew house that she had inherited following her father's death. Her husband was simply named for his interest, and this is interesting because her name is before her husband's name. We're able to reconstruct women's property rights and see whether the property came from the family, i.e. it was inherited, or whether or not she had purchased it with her husband. So usually when wives were named after their husbands, they appeared as just simply interested parties in their husband's economic arrangements rather than active participants. I'll give another example here. So for instance, Catherine Caldwell was named after her husband, Patrick Wilson, in a suit initiated by her husband before the Commissary Court in the same year. Patrick, as a plaintiff, alleged that he had purchased a horse from John Caldwell's wife at the Glasgow Fair, and that he was still waiting for the animal to be delivered to his dwelling place. So if Patrick was to die before receiving the horse, Catherine would have been entitled to seek restitution of the animal or else receive compensation from her husband's debtor. And this is why many married women's names were simply included in contracts, because it gave them certain rights if the relationship was to end to retrieve the debt. So the historians Gordon Disbrazy and Karen Sander Thompson have suggested that the stock phrase "for his interest" signaled both the nominality of the husband's role in the transaction and his legal responsibility for it. On certain occasions, it appears that the stock phrase "for his interest" also prevented husbands from avoiding litigation by asserting that they did not consent to their wives' legal actions. So, for example, in June 1670, before the Commissary Court, John Clark, who was a lawyer in Paisley, told the court that he did not consent to his wife's appearance before the court as it would prejudice him as her husband. Now, his wife, Agnes Montgomery, was a remarried widow, and she was embroiled in a suit relating to property connected to her previous marital estate. So recording a husband's interest in his wife's lawsuit clearly bypassed the necessity for consent in certain situations. Remarried widows like Agnes were regularly embroiled in litigation concerning the distribution of inheritance and marital property. Their subjugated status and position as wives in legal theory did not just simply absolve them from answering as defendants in lawsuits. So just to briefly conclude, it is evident that Scotland's property laws were relatively generous to women when compared to coverture, and that the Scottish legal system had more in common with civil legal traditions elsewhere on the continent. investigating women's rights to property before local systems of justice in early modern Scotland as viewed and articulated from the bottom up, rather than their position within male-centric legal handbooks and treatises from the top down, vividly details the type of property women claim to own or use throughout their lifetimes, and statistically reveals the extent of women's participation as plaintiffs and defendants in lawsuits concerning their property. Looking closely at women's legal actions before the courts unearths their varied participation in legal procedures, showcasing them as noisy plaintiffs, belligerent defendants, or unwilling bystanders in a range of legal actions concerning their property. Examining the property rights and concerns of early modern Scottish women substantially increases our understanding of the social realities of women from the past, and reveals how their experiences of law and patriarchy compared to, or at times differ from, the experience of women living elsewhere in Britain and Europe. Thank you.
Thank you so much, Rebecca. That was fantastic.
Thank you. Oh, sorry, I'm back.
Well, while we wait for people to ask some questions, I will make the most out of my privileged position as moderator. And yeah. I'm going to ask you a couple of questions, if that's okay.
Of course.
So you mentioned at the end that there is more similarities between the continent rather than England in some aspects of property rights. Where would that influence come from? Did Scottish advocates or legal officers, were they reading continental treatises or theoretical books? Where would that come from?
Yeah, well, I think mainly throughout the medieval and early modern period in Scotland, the law was very much in a transitionary, it was kind of, it was developing across this time, and it was very much, it followed different procedures in English law. And I think you can kind of see this coming to light with the fact that Scottish lawyers in the 16th century, or Scottish students, sorry, went to Holland, they went to the Netherlands, they went to France, and that is where they trained in law. And they were therefore receiving a lot of civil legal procedures whilst they were abroad in the continent, and it was coming back into the country in that way. I think there was, of course, there is still influence of English common law in Scots law as well. To me, it's kind of a mixture. So it's not coverture, but it's also not, I'm not trying to say that women were kind of legally free to do what they want in Scotland. They were still very much living underneath the patriarchal rule of the law. It's just, from what I've found in Scotland, there seems to be more similarities with what's happening in France. So women in France also received customary shares of property following their husband's death. And in England, apart from London and York, basically a husband in England could leave his movable estate to whoever he wanted. And in Scotland, you weren't allowed to do that. A husband was legally bound to provide his widow and children with shares of property. And that still stands true to this day in Scots law. So I think by looking at Scottish legal, looking at Scots law through the lens of women and property, I'm finding out some interesting new things. But also, I must say, I heavily rely on the work of, Scottish legal experts who are much more equipped with understanding the system than I am. I'm basically just kind of understanding what's happening in the courts at ground level.
Yeah, thank you for that. So we have a question from Stephen. He asks, thanks very much for a great paper. What happened to the property of a widow at their death? If the widow had no children, did the one half of her late husband's property revert back to his family? And then he added, and if she had no sons, only daughters, did property revert to the late husband's family or her death?
Yeah, that's really good questions. So if a widow had no children and she died, the property did not revert to her late husband's kin. It would have went to her nearest of kin. This is because when a widow inherited the third or a half share of her late husband's goods, they belonged to her. The only property that did not belong to her was the land, so the kind of the heritage that would have reverted back to the late husband's kin. But upon widowhood, women kind of, they subsumed ownership of these goods. If she had no sons, only daughters, the property would still go to the daughters. I think what's interesting actually, and I didn't really talk about this too much, is married women in England could not make a will without the consent of their husbands. I think you get less than 4% of women's wills in England at this time are married women's wills. I've done a study of women's wills in Glasgow Commissary Court as well, and of the 6,000 wills that are registered kind of across this period, 30% of all wills, so men's and women's, are married women's. And this is really interesting because what you're seeing happening in the court is that when a married woman died and she didn't have any children, if she didn't appoint her husband as her executor, the property would revert back to her family. So you're getting a lot of suits between sisters taking their deceased sister's husband to court. It can get quite complicated, but you're finding these kind of disputes going on within the courts, and you're not getting this in England to the same extent. So if a widow died without leaving a will, for example, her property would have just went to her nearest of kin, not back to the late husband. Basically, as soon as the husband died, and if she had no children, she was a free person once again. She could do kind of what she wanted.
Yeah, thank you for that. Well, while we wait for some people to gather their thoughts, if that's okay, I want to ask another question. So you mentioned the jurisdiction between the commissary and the borough courts. The fact that they were, each one of them were dealing with property rights. Can we say that we are here facing different laws rather than one single law, and were they overlapping? How would you put them together?
Yeah, that's a really interesting question. So the commissary and the borough courts were two kind of different courts in the sense that the borough court was a civil and a criminal court. So you would have had a lot of women being brought up for theft, or a lot of credit and debt networks going on within the borough court. And then the commissary court was primarily dealing with disputes relating to someone's estate. So someone has passed away and a debt is owed. However, what I mean by saying they're overlapping is I've also found examples in the borough court of women bringing executory disputes there. You know, so sometimes it's hard to understand why they would go to either court. But I think the difference in Scotland is that women could appear before either the borough court or the commissary court or bailey courts or regality courts. They didn't need to go to specific courts like English women did to negotiate property rights. So English women, if they were married, had to go to Chancery, had to go to request to get round coverture. You're not getting that in Scotland because the Scottish legal system didn't have that kind of, kind of blocks that kind of directed women to go in certain avenues. You're not finding that. And I think that's why I'm finding women basically participating at quite high levels in the borough courts and the commissary courts. But I think that's mainly because, and I would suggest, I think some historians might disagree with me, but I would argue that coverture is not present in Scotland to the same extent as it was in England.
And what would be the standard, if there was a standard, in terms of if they wanted to defend themselves upon court or litigate something, what would be the most common procedure for them to take?
To actually go to the process of going to court? Yeah. There was many ways. I think what shocked me the most, I'm making my way through St Andrews Borough Court records, is that women went to court frequently and often for very minor sums of money. I found a woman who had approached the borough court over 20 times in 1 year, and she was basically asking for quite small scale debts. It was quite varied, and I think the process of going to court in the early modern period was much more frequent than what we as, in our modern world think of going to court. I think people were they were highly litigious in the past in comparison to us today, to women today, I would say. But women could go to court in a variety of ways. They could submit legal evidence, as during the 17th century, there was a growing importance to have kind of written proof of property arrangements, and this is why you're finding a lot of women registering marriage contracts in the court on a really high level. And I find a lot of daughters of like lowly level merchants who are doing this. So it's basically, it was really important to record your rights, because in order to prove that you were owed something, you needed to have writing. But also women could go to court under oath and just basically pledge to, there's a lot of references to women raising their hands to heaven, and by the whole evangel, they claim their truth. So there's a lot of oath taking as well, but it's quite varied. But I would say, to me, because I look at property, most of the women that I'm coming across in the courts are submitting written evidence of their legal rights, and this was really important.
Right, okay. And do you find to have any difference between the legal exercise in the Highlands and in the Lowlands?
That's a really good question. I'm finding regional differences in the Highlands, yes. So I'm finding, I was actually quite shocked to find the Inverness Borough Court, in Inverness Borough Court records, the Baileys were sentencing a lot of people to death for various things, and I haven't really come across that in Glasgow Borough Courts, which was quite shocking. But I think there's still a reference to the laws of this kingdom, and that comes up quite a lot in the records. So to me, there wasn't really much regional variation apart from certain practices. So for example, in Glasgow, there was a custom called St Mungo's widow, and this allowed a woman who perhaps was living in a tenancy, if her husband died, she could stay there until her own death. And this was specific to Glasgow, because it was kind of an archbishopric region as well. But I think in Inverness, it's the only differences I'm really coming across is that I'm finding Gaelic women, and unfortunately, the thing with Inverness as well is it does seem to be women from the higher levels of society. So it's the same kind of families coming up. The Cuthbert family was quite big, the Frasers. But to me, I think the most important thing of looking at Inverness and adding this to many research is it's painting a more vivid picture of what's happening across Scotland, because I think we do tend to focus on the lowlands, you know, especially the kind of central belt, the Edinburgh, the Aberdeen, Dundee, Glasgow. And I think it's important for Scottish historians to kind of delve into the Highlands. And I understand that a lot of Highland historians might not like me doing that, but I hope to make them happy with future when I look at more detail.
Yeah, I thought about that because obviously when we look at witchcraft trials, for example, there are different jurisdictions between the Highlands and the Lowlands, especially because in terms of witchcraft trials, they will take place in maybe baron courts, or it will depend on each individual clan. So I wondered if maybe there would be differences, you know, in terms of women litigation and property rights.
Well, like I remember, I found one case in Inverness Borough Court. I don't know, Alan Kennedy's written about it recently. There was a witchcraft trial in the Borough Court, and it shouldn't have been there. You know, it shouldn't have been tried there. So I think sometimes it is quite confusing what's going on in the past. It's sometimes difficult to know why a specific case is being heard in a borough court over a commissary court. But I think I would still say that there was a legal system it was a Scottish legal system that was kind of followed throughout the land to varying extents.
Yeah. And would women require some sort of lawyer or advocate to help them with their cases? Obviously, that will be more focused in people from higher ranks of society, but would that happen as well?
Yeah. A lot of women had lawyers, and they weren't necessarily from kind of wealthy backgrounds. You know, Glasgow had a faculty of procurators, the commissary court, and this was kind of a group of lawyers that was set up in the late 17th century. But luckily for me, the court case will say if a woman was appearing through a lawyer, or if she was appearing by herself, so you can kind of reconstruct whether or not women kind of required legal assistance. Actually, there are some cases where women actually schooled the judges on aspects of the law. So I found an example of a woman telling a town bailey that he was not able to answer on this case because he was secretly given information to the plaintiff. So you're finding different things out. But I think many women were more than capable of defending themselves at law. But yes, of course, when you're getting into the higher kind of, especially when you're getting into the nitty gritty of property arrangements, you do see women mainly appearing through a lawyer.
Where would they get information from legal expertise?
Lawyers or women?
Women.
Well, like I think perhaps it's hard to find that kind of information out. But I did find an example which I thought was quite funny of a woman who had stolen a copy of Stir's Institutions. So this was like a legal handbook that was written in the late 17th century by one of the big kind of Scottish faces of one of the big Scots lawyers. But yeah, she had stolen this court book and she was refusing to give it back. So I don't know if she could read it or not, but it's evidence that women had legal handbooks in their houses. So I'm not really getting that, but I can find nicely examples where they do. But I yeah, it's hard, but I think women were more than capable of knowing what their rights were.
And if they did require a lawyer, for example, that wouldn't cost them too much then?
It depended on the kind of nature of the case. So yes, they would have had to have paid for a lawyer. The thing with in this time is if a defendant lost a case, they would have to pay the expenses of plea to the litigant, so to the main plaintiff, and this was kind of how they would fund their litigation in this manner. It depends. It could range from a few shillings to pounds Scots. I haven't actually looked too in detail at how women actually funded that, but it's definitely something that I'll have to think about. So thank you for bringing that up.
No worries. Thank you.
Mm-hmm.
Right. So we have another question from Robbie. He asks, was there prejudice from the courts against any of the women who took cases to court? For example, a marriage contract of a widow seeking her late husband's estate, or did the courts always act fairly?
That's a really good question. Well, I think most of the women who, for example, so widows who were taking their late husband's family to court, they always produced evidence of a marriage contract, which very clearly stated their property rights. So it would say they were owed this share of movable goods, this share of land, and this is it also reiterates the importance of having a marriage contract, because this was really necessary for women to get more than they were due at law. What is interesting in Scotland, though, is you're getting examples of women who had not written a marriage contract, and they go to court and ask for a third share of their husband's goods. And the courts, there was a line I found in Glasgow that I found really interesting, where the lawyer had said, "For it is well known that women in our land receive this third share of goods," and she won it very easily. I think it wouldn't have went to court, it wouldn't have got to the final record if there was any major kind of legal question mark over it. Usually they're fighting about the nitty gritty of how much they're owed, rather than if they're owed or yes, or like if they're owed in general. So I think the courts did always act fairly in that way. They didn't. I think also the system of property in Scotland, it was also to prevent widows from becoming a burden on the town council or poor relief. There was systems of poor relief at this time, but I think husbands had to leave their wives' property because it also facilitated the distribution of wealth within the city much more widely. And for Scottish widows, lawyers actually do say that she is owed a share of her husband's estate so that she may the more easily be married with another man. So it was for her to bring this kind of share of property into another marriage. There wasn't this kind of, you're not really finding wealth being diverted to the male line unless it's huge amounts of land. And yes, of course, then you are seeing eldest sons receiving that. And then the success of women, that's a good question. So it seems that women in the borough and the commissary courts, there was more women in the commissary courts, and I think this is because it primarily dealt with testamentary disputes, and this is where you're finding a lot of widows and basically arguments over inheritance, marriage, and widowhood, and these obviously all of these issues affected women. The borough courts, there is still a higher percentage of women than there is in other countries. However, the borough court records can be quite fragmentary, and I'm trying to basically piece together. I'm trying to give a picture of what their participation is like in these courts. But women were generally quite successful when they went to court, and there's examples of women who are arguing with the late husband's kin or the late husband's creditors, and they're winning their cases. So it wasn't in the past, it wasn't just simply that women were subjugated and that was, kind of closed book. They lost a lot of property and rights upon marriage or upon widowhood. It's more of a complex picture, and I think what I'm trying to do in this research is kind of explore issues that affected women, but also issues that affected men in many ways, because property to me is it captures a lot of litigation that affects a wide strata of society and not just women. I'm just reading these questions, sorry.
So Robbie is also asking if there were any women that offered legal action or advice specifically for other women.
Yes, so women often acted in legal offices, and these were offices that they could appoint one another. So, for instance, in Scotland, we had the Office of Commissioner or the Office of Factor, and these offices allowed a person to collect debts on behalf of another person. And you're often getting a lot of husbands appointing their wives as their factors when they were traveling from Glasgow to Barbados or France. And you're also getting women appointing their sisters, women appointing their daughters to do this on their behalf. And it goes to show that it's not just simply men who understood the intricacies of the law. Women were also more than equipped. I found an interesting case of a man who was I think he was in Holland at the time, and he sent letters home to St Andrews, and he basically said, I want my sister to act as my factor in my behalf. And she replied and says, I don't want to do that because I don't want to travel around the country. So, women were more than able to accept that position, and men also recognized that, but many women didn't want to do it as well, which is also important.
That's really interesting. Do you know what he replied back to that?
No, I don't know. I'll have a look if I can find the letters, but this was just an example that I've seen in the court record where she basically had said that she didn't want to do it and that her brother had sent letters from Holland, which I thought was quite funny at the time.
Yeah, no, that's really funny. Well, so I think we are going to wrap up for today if no one has any other questions. Rebecca, I would like to thank you so much. I mentioned to you the importance and how relevant it is to me personally, but also to historiography for us to discuss Scotland and other parts of Britain apart from England. So thank you so much. We really appreciate, and that was amazing, really. Thank you.
Thank you for having me. It's really lovely to meet you virtually and meet everyone else virtually. And I think what this group's so important. I think it really is. It's fantastic. Thank you.
Yeah. So thank you so much. And well, I see everyone in the next episode. Thank you, Rebecca.
Bye.